Good morning, members of the jury. This is now day 2 in the case of the state of Iowa versus Kelsie Ray Thomas, case FECR 011-664. In this case, again, the state is represented by Assistant County Attorney Maureen Hughes and Wapello County Attorney Ruben Neff, and the defendant is personally present with her counsel, Alan Cook and Nicole Jensen. Members of the jury, you may notice cameras in the courtroom from time to time. I want to emphasize again, as I told you last night, that your photographs will never be taken during the course of this trial. The first order of business here this morning is the reading of the trial information and the stating of the plea.
May it please the court. In the Iowa District Court for Wapello County, State of Iowa versus Kelsie Ray Thomas, defendant, criminal cause number FECR 011-664. Trial information reads as follows. Comes now Ruben Neff as Wapello County Attorney and Maureen F. Hughes as Assistant Iowa Attorney General, and in the name of and by the authority of the State of Iowa, accuses Kelsie Ray Thomas of the following crimes. Count 1, murder in the first degree. Said Kelsie Ray Thomas on or about the 19th day of July 2018 in the county of Wapello and the state of Iowa, having malice aforethought, killed Cece, a child, while committing an assault, and the death occurred under circumstances manifesting an extreme indifference to human life, all in violation of section 707.1 and 707.2e of the Iowa Code. Count 2, child endangerment resulting in death. Child endangerment resulting in death committed as follows. Said Kelsie Ray Thomas on or about July 19th, 2018 in the county of Wapello and state of Iowa, being a parent of CC by an intentional act or series of intentional acts, used unreasonable force, torture, or cruelty against CC resulting in the death of CC in violation of section 726.6 subsection 4 of the Iowa Criminal Code. True information, the defendant has pled not guilty to these charges.
Members of the jury, at this time the attorneys will have an opportunity to make opening statements. In doing so, they will explain to you what they believe are the issues in this case and what they expect the evidence will show. The statements which they now make and the arguments they will later make after all the evidence has been received is not itself evidence and should not be considered by you as evidence. Also, any statements they may make about the law is not necessarily the law of this case. The court will give you the legal instructions at the conclusion of all of the evidence. Since evidence often comes in piecemeal and out of chronological or logical sequence in the trial of a lawsuit, the statements of counsel are merely to put the facts in perspective. They are intended to give you a thumbnail sketch of the case and to outline the evidence to better aid you in understanding the issues. So please give them your close attention, beginning with the opening statement of the state.